Woohoo! Tcholakova, come
Welcome,
here. Welcome.
Irena, Irena. Hello,
Welcome
Irena.
back.
Welcome.
Hello. Do you all hear me?
Okay.
Do you hear me?
Yes.
Oh,
Perfect,
okay,
Irena.
perfect. So,
Okay, a
first
first
of all,
presentation for you, okay?
yeah.
Okay. Bueno, hola a todos. Nos vamos con la presentación de Irena. Welcome. Irena is from Sofia, Bulgaria. Currently finishing additional master in law and technology at Tilburg University. The work experience in legal sphere so far showed that that is definitely not a file, that is lack or change and new developments and in the light of this. AI, VR, and augmented reality. And intelligent artificial, virtual reality, and transformations, and augmented reality. As the next level innovation taught with India's curious transformation. Delighting and thankful to be part of the conference. Irena es de Sofía, Bulgaria, pero ella está actualmente en Países Bajos, Holanda. Ella hizo su máster en leyes, en leyes y tecnología en la Universidad de Tilburg, y toda su experiencia laboral en toda esa parte legal, normativa, y tiene experiencia en desarrollos en realidad virtual, realidad aumentada e inteligencia artificial. Bueno, bienvenida Irena, muchas gracias por estar aquí, disculpa por el ladrido de mi perrito.
Nah, no te preocupes, no te preocupes. A ver, we can make a bigger house and press the button to Irena to start. And Daniel, all audience
Yes.
want to know Irena?
Yes, please, all audience, press number 4.
4? Okay, 4.
4. 1, 2, 4.
1 to 4. Perfect, Irena. Are you ready?
Okay. So, hello once again. I would like first to start with a huge thank you note to all the organizers to the conference for giving opportunity to speak today about some legal issues. I will try to make it very simple and short in a way that I can put a lot of articles and long explanations. I really hope that I cleared all the presentation from those things so that I can focus on the main issues. Briefly, some information about me. As it was already said, I'm currently having my additional master's and I'm living here in the Netherlands. And I obtained my first law degree in Sofia. Managed to work in national and international law companies in the sphere of commercial law, international arbitration, and lastly in a US company dealing with bankruptcy procedures, which was very interesting. So on the topic about, can we put the next slide? Yeah. So, and the next slide, because it was a short information. We have, I have separated the presentation into two main topics. The first one is about intellectual property. I will try to touch like some very important issues about the copyright and some trademark issues. Like the time limit gives me this window only to explain just these two parts of the intellectual property field. And the other one is about data protection and the GDPR. Mainly, if I have enough time, I will try also to put like some practical implementations, like when company, for example, wants to use artificial intelligence, what are the things that the company should do? So can we have also the next slide? Okay, perfect. About intellectual property. One of the latest topics that are getting more and more into the light regarding development of artificial intelligence and deep learning is about the novel output that such such algorithms will make, for example, is music or artworks or poems. And the main question that comes from this is, are all of those works protected by copyright? The answer brings together like technical, legal issues, as well as even philosophical questions. But in order to determine what constitutes a creative work, among a lot of other criteria, most national legislations focus on authorship and originality. In the Berne Convention, as stated in the slide, we do see that the protection shall operate for the benefit of the author. Under the European Union copyright law, there is no definition about author, but the case law, all the cases that was filed before the European Court of Justice, established that only human creations are protected. Like, so on one of the ends, we need to have like a human that is creating the copyright protected work. As AI systems do not have a personality, they could not imprint on what they produce. Authorship is beyond their limits. I would like to mention one specific example, the next Rembrandt, which is a computer-generated 3D printer painting developed by a facial recognition algorithm that scanned data from more than 300 pictures from Rembrandt. And the process lasted 18 months, and at the end, a new picture was created from this from this algorithm. There is, I'm mentioning this, and later I will explain why I'm giving this example. There is, for example, for sure, no specific prohibition that works created by artificial intelligence to be copyright protected. However, the case law show one common outcome. Even I have stated a couple of case law. One is coming from the US, and it's also there a copyright a copyright office has declared that it will register an originated work of authorship provided and created by a human being. Also, in European Court of Justice, the very famous Infopack case is also stating that the author and the copyright protected work should have own intellectual creation, like the author is the one that it's creating. A very interesting approach is coming from the UK copyright law, Copyright Design and Patent Act, which is stating that in case of literary, dramatic, musical, artistic, and which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. So an interesting approach that can maybe solve the problem is that if we define in which content, like the author will be person that is standing behind the computer and pressing the button, or the person that has created the algorithm itself. This is a development that it's that if defined in legislation will give good light about how to resolve the problem. And this goes also with the Rembrandt 3D printing, like the person that creates the algorithm or the person that presses the button and the program creates the picture. So slightly to focus on the trademarks. For a trademark to be worth protecting, one of the main requirements are the distinctiveness, lawfulness, truthfulness, novelty, and the use in commerce. What are the difficulties here? Is first that the scope of trademark covers only real goods. And can we go and extend this to cover also intangible virtual representations? This is still a case. A second kind of issue is that an owner may face some hard to prove damages suffered from the use of its intellectual property of the trademark in the virtual reality platform. As stated in the slide, I have provided the Pokemon Go app. The idea is that for example, the Pokemon Go may use the logo of a company because of the Pokestop or the gym, which is actually located at a company store. What if the store does not want to be associated with this Pokemon brand? Can it prevent the use of the logo and the brand? On one side, the company will say that people using Pokemon Go can attract more clients to the specific shop. But on the other side, the brand owners may start working with the virtual creators to provide license for virtual goods. I mean, I go a little bit before what I wanted to say. On the other side, like the person that the location that has been used from the Pokemon Go, like the company does not want to be associated with a specific program as a Pokemon Go. And the main outcome is how the company that the Pokemon Go app is using their location for the application wants to be known from the public. If it wants to be associated or if not, like it depends about the image that the company wants. This was in very, very, very short about those two topics. Maybe I want to slightly mention about the avatars, since we are all avatars here in this virtual room. Very interesting part is that if the avatars are designed, if the people are designing the avatars themselves, they could be subject to copyright trademark lawsuits. The fictional characters' images, together with their unusual character traits, are protected by copyright. So users who copy enough of the visuals, character traits, or both to be copyrighted expression and not simply an idea might be infringing, actually. So there is also room avatars to be protected by copyright, depending how much the originality has been used when creating the specific avatar. Maybe a brief conclusion that I would like to draw up here is that before making any specific legislation about copyright created from artificial intelligence or deep learning algorithms, the artificial intelligence needs to be properly explored and understood, but still, like the artificial intelligence itself, it's under construction and it's under development, and no one is actually having quite a broad idea how everything is going to develop and how it will end up, and how exactly artificial intelligence will be able to use all the information and data that has been input in the algorithms. So this is quite a slow process, and European Union is in the very beginning of creating legislation about artificial intelligence. Still, there is no complete paper about it. It's still undergoing, like all discussions. So moving on, regarding the data protection, can we change the slide? Okay, so data protection is very, very hot topic, of course, because all the changes that are coming with the GDPR, the regulation, are still ongoing, and a lot of companies are still adapting to the process of collecting data and processing and also defending personal data of the subjects that they have collected. So first of all, maybe I would start with some practical information about what companies, if they're using or planning to use artificial intelligence, should do in organization, on an organizational level, in regards with the regulation that the GDPR provides. First of all, one of the main important things is when you're collecting personal data of the subjects, like the people that are using your that are customers to your company, you have to say what it will be used for what specific goals this data will be used. This is not according to the presentation, but I would really like to slightly point out the practical issues. Like, And maybe if I have enough time, I will go on this slide of the presentation. So what is very important is to say when you're collecting personal data, what is going to be used for, and not using it for anything else. Like the specific reason that you stated that for one subject that you're collecting all type of personal data, and whatever you say in the beginning, that's it. Like there is no way for changing it, and there is, if you want to change it, you need to collect it again, but that's another topic. Another thing is that also there is a limitation for how long you can hold on the data, and those are a lot of specific cases over there. Additionally, once the data has been collected, you have to be able to tell people what data you hold on them and what's being done with this data. You also need to be able to alter or to get rid of people's personal data if this has been requested from you to be done. So data needs to be identifiable and accessible at an individual level. And this is also very important. All the rules that the GDPR has will actually help to increase the transparency in the artificial intelligence. One of the topics that has been quite a lot of there has been quite a lot of discussions on, like the transparency on how artificial intelligence and algorithms are using and how they are making the decisions. Article 9 from the GDPR requires that there should be no discrimination using data, which is very important when, like we all know that there could be bias and that algorithms, the way that have been programmed, at the end that there could be some kind of a discrimination. There were also cases about this. So it's very important, and right now it's another topic that people are working on, is creating an ethical algorithms that do not that diminishes as much as possible the probability of any kind of discrimination when the algorithms are used. So going back to the presentation, since we have a little bit more time. The GDPR, as already mentioned, contains rules that directly and indirectly limit the development also of the use of artificial intelligence. Like, first of all, I discussed like what a person needs to do if he wants to use artificial intelligence in their company. And right now, from another point of view, we'll look again at the same regulation, seeing that there are limitations that it imposes on the development of artificial intelligence. One of the first things is that companies must have humans to review certain algorithmic decisions. First of all, this raises a lot of labor costs of using this, and also it takes a lot of people to be trained how to actually do this and how to review the decisions. Another thing is that which is quite demanding from the companies. Each one of them have to explain the logic behind their algorithm decisions and have to explain if it's an ambiguous requirement, that is an ambiguous requirement that needs to compel the companies. I'm sorry. Yeah. In short, like the companies have to explain the logic behind their algorithm decisions. Another point also is the right to erase data could reduce the accuracy of some algorithmic models. We all know that machine learning and algorithms that are in fact like the basis of the artificial intelligence work with data. And data that has been collected most probably not from the last 2 weeks, but from a longer time. And in case of erasement of the data, like a lot of the process, like quite enough part of the process will be hard to be finished. Another thing, as we all know, are the huge fines that the GDPR provides, which means that all the time a non-compliance with the articles of the regulation will go and will result in penalties. And the penalties goes for the companies, and they are quite high, as we can also see like the case with the Facebook and Cambridge Analytica. So this was in very, very short. I will end up here because I would like to hear if you have any questions. Thank you.
Bravo! Please press F2 to Irena. Saying hearts. Okay. 4 times to the question, you need to press this button, the 0. 0, 0. Ah! One have a question? In second. You can put a little bit your volume of your mic.
Excuse me?
You can up the volume of your mic, please. A little bit.
Can you speak louder,
How
please?
do I
Juan
Yeah.
do that?
se escucha lejos.
Sí. We are so close. Maybe he's in Colombia and we are here in Netherlands. It's very far.
That's the
Hola,
reason.
hola, hola. Hola.
Yeah. Okay.
So, Irena, I have a question regarding the limits of the legal participation of the entities on regarding artificial intelligence and for example VR. Does it goes beyond a country or for example the European Union and goes on digital? Is it going to be like that in the future, like a worldwide how do you say a worldwide legal approximation for artificial intelligence, machine learning, and these virtual technologies, or how do you think is going to work? For example, you have some legislation in Colombia where I am. It's very different, but do you think that is going to be like a whole legislation that can apply to this virtual world?
Thank you really for this question. I have been also asking myself what will be the best approach when regulating artificial intelligence. Having first of all the idea that at some places on the planet the artificial intelligence is way more advanced than on other places, most probably, and so far the most easiest solution will be maybe some kind of a regional legislation or some kind of a international bodies, and states that participate in those international bodies will have and will be attached to a specific regulation regarding artificial intelligence. Maybe those are the best approaches. I really don't know. So far, I know that European Union is really working on this. China is also working on this, and the market over there is very high. Is on a very high speed. India is also on different, and US is also fighting for a lot of rights and regulation about this, because also there are a lot of startup companies that are using it and having it. At some point there will be some cases, and also like a very big thing in the US is about this autonomous cars. Only this issue is striking a lot of debates, and having autonomous cars daily use means that there should be regulation about all the casualties that could happen. And artificial intelligence and machine learning stays over there. So most probably they will also, like the US, will have a different and separate approach from other countries. So it's either a regional kind of approach, or either like in international bodies, they accept rules, and parties and states that are into those international bodies, they follow those rules. Those are the approaches according to me.
Thank you very much.
Wow. Thank you.
Oh, thank you.
Someone have a question? Cindy have a question.
Alexa, question from Colombia. Teacher Monica. Irena, I heard in your presentation. ¿Hay un eco por ahí? I heard
Lo que es
you in
Néstor.
your,
Ya, dame un segundito. Ah, ya.
okay. I heard in your presentation that you are from Bulgaria. You want to go back to developing projects in your country?
Oh, thank you so much. This question put a big smile on my face. Yes, actually, it will be very, very interesting. There are a lot of startups going on in Bulgaria, not right now, but from the last maybe 10 years. There was a specific program from the European Union that helps people with ideas to get money from the union and developing their ideas and see how it goes. And also we have a lot of IT specialists. So yeah, developing and trying to do something as a project in Bulgaria will be very interesting. Yeah, I'm also thinking about this option. Thank you so much for asking me.
Well, thank you for sharing your expressions.
Thank you.
Wow, super nice. And Daniel, you have a question?
Yes, we
Or
have
someone-
some information from YouTube.
Okay, tell me.
Astrid Niño says, how nice presentation. And Julian Andres says, greetings from Colombia. And that's it.
Thank you so much. I really hope that the information that I provided, I really tried it to be in short and to give as much as practical as possible.
You know, no, we have one lawyer in here. It's very important when we develop these projects in technology, in virtual reality, augmented reality, mixed reality, and artificial intelligence. Every time when we develop something with technology, we use data. Then is the reason you can contact Irena because she will be a specialist in this topic. And also other lawyers, like for example, if you're working in Colombia and you make a project in Colombia, it's very important, like us. Camilo have a question. You have a project with the data? Tell us.
Yeah. More than project is like a successful case that we have in our country. We with a recognized company in the world that is Nielsen. Maybe you know, Irena.
No, this one. No.
Nielsen is one of the biggest company in the world that have that manage the data, the consumer data, and they give prognostication and give reports to other companies about their customers and their behaviors. This is the how works that company.
Mm-hmm.
And we create an experience with them when here in our country we have some stores, local stores that is located in the neighborhoods, and we work together with them in order to recognize the products that they are sold in order to give more information in real time and more precise data for them. But here, as you mentioned in your speech, it is important to be clear in the documentation and the how you obtain the data and who is the owner of that data. Is the store, is the customer, is the company that built that, or is the company that payment for that. There is really important legal aspect, and it really is important for when you manage AI projects in this kind of system.
Yes, everything like especially the so-called sensitive data, but it's another part of data in general. But yeah, since data nowadays has been used for some companies and organizations to get profit from it, and it's personal data from all of us, it should be regulated, and it should be specific norms that goes with liability about this. And when somebody infringes and when somebody is doing unlawful stuff with the personal data that you have not given any consent to be collected, there should be consequences. So it's really, really important since as I said before, like some companies are getting profit from data. Yeah, I wish you a lot of success with this.
Thank you, Irena.
Thank
Hope
you.
we can visit you to
Number 2, we can say thank you for Irena. Please press your button 2. See, all audience can see.